Namaste ji, namaste. Welcome to Courtroom by TLOI. And today, after the 29th of March 25, that was the last time I made any video on this particular topic, wherein I told people that assume that this is a reality, and well, it became a reality on the 20th of May 25. So after 29th of March 25, today is the day that I'm again making a session on the 3-year practice clause review judgment that has now been given by the Supreme Court in a 2:1 decision. So let's talk all about it. Now, since March, on the 15th of March, from the 13th of March, in fact, there was a hearing in which the CJI had mentioned that the 3-year practice clause is going to stay, but the modalities might just change. And one of the other judges, Justice Chandran, who had dissented today, had mentioned that that he's not afraid to say it in open court, that this petition is sponsored by coaching, etc. And well, his views were set in stone at that moment of time, and I could deduce what was just about to happen. It was just a logical deduction. So on Twitter, I'll post the screenshots here, and this is I do not have any mystical abilities, because it's like the third or the fourth time that we have been correct in this. But it was just a logical deduction as to what is going to happen, and well, the same thing happened. That was 1 + 1 + 1. That model is a necessity of today's time to address all stakeholders, especially the bar, the college, and especially the student, the colleges rather. Now, the bar's main criticism is that these new fresh recruits aren't exactly as aware of the law in motion. So they might be very good with law in books, but the bar finds them not to be exactly up to the mark in terms of A, the conduct, the behavior, especially because, well, power tends to get onto each and every one of our heads. And B, perhaps they have not seen the law in motion, so they do not know lawyer tactics, they do not know the courtrooms as such. So they were extremely critical of that point. So that needed to be addressed. Then the second thing that needed to be addressed was that these examinations, they are not being conducted on an annual basis. Consider the Delhi Judicial Services exam. It was last conducted in 23, and the maximum age for the exam for you to attempt is 32. So if after graduating from law school in a 5-year setup you'll be graduating at 23 considering no backs, and in a 3-year setup you'll be graduating at 24, to even aim to be a judicial magistrate of the first class, you need to wait till 26 or 27 before you are eligible even to write this examination, which doesn't get conducted on an yearly basis. Case in point, Jharkhand prelims was conducted in 24, and now the mains were never conducted, and now thanks to the protests, legit protests, they are saying that the prelims has been cancelled, and that provides a lot of stress. So not everyone has a lot of money to survive for all of these years. So the counter argument then comes in that this is a job, primarily speaking, which should be focused on lawyers and litigants and not from the terms of employability. Accepted. However, that eradicates the majority of the people who even consider this examination in the first place. That's why I have not been willing to engage with a lot of folks who have never really prepared for these examinations, and they keep on pontificating in a vociferous manner about the practice clause without knowing the ground reality of the situation. When CJI Suryakant decided to hear this matter, it was, I had great hope. And why? Because he had attempted these examinations. So even at the bench, we all know that there are a lot of nepo kids who automatically get placed at the High Court, then they are elevated to the Supreme Court via the collegium system, the often criticized collegium system. We won't get into the criticism of that model, because every model has its pros and cons. The nepo kids, if they were hearing the matter, they would never really truly understand the pain of people who wish to get into judicial services, because many of the times these examinations, they are just not the first priority. The first priority is the UPSC CSC. Then these examinations are placed as the second most priority. And these examinations never really make all that much of a noise either, because they are state level examinations. They are not at the national level, and they are not exactly glorified via films, and there is an entire UPSC coaching ecosystem that exists. So when Justice Chandran said that this petition is sponsored by the coaching folks, it was absolutely baseless and incorrect. I humbly disagree with the judge there, and well, that was reflective of his bias that he was carrying in terms of this review, because he had said that I've seen the interviews. Which interviews was he referring to? I'm sure some on YouTube that must have been conducted by some coachings with some retired judges, or you never really know who he was referring to. And the judiciary coaching ecosystem doesn't exactly exist in the country because, well, judiciary coaching, the subjects are extremely technical, and this entire domain is suited for more one-person teaching models, I would say, rather than the classic traditional UPSC coaching style ecosystems, because the examinations are of a very different nature, and they're as tough and as rigorous, and they command as, or require as rigorous a prep for as rigorous a prep as UPSC, perhaps, to correct my sentence. So I do not agree completely with the honorable judge's viewpoints, and I do not agree with his dissent as well, wherein he has labelled that judiciary folks will be making careerists and not jurists. Well, the less said about the elevation mechanisms to the Supreme Court in the country, the better it is, because, well, I'll leave it to the executive, the perennial tussle between the judiciary and the executive, and their permanent, logjam. Khair. But let us move on, and let us discuss now what this judgment really is. And I'm sure that you have already seen 10,000 trillion videos that are already out there. I didn't make a video on this for so long. Well, A, because there was nothing much to report, but however, a big shout out to Shubham sir of the Law Tales. He was my source to go to for very authentic, no nonsense, no hype sort of coverage. And well, big shout out to Professor Mustafa for raising this issue so vehemently at various points of time, and given that his academic background and his stature in the overall legal academia, it was a big boon for the entire tussle. And then big shout out to Jayant Raghav, the main advocate for Bhumika Trust. Big shout out to Pinky Anand ma'am, the senior advocate, and Gonzalez sir, and all the other advocates that were involved. And pretty much it was not a fight, it was just the judgment that was delivered by Justice Gawai wasn't exactly very thought out. It was just very akin to demonetization at 8 p.m. That just like that, it was a bad decision by the government. Just strike off the currency notes at 8 p.m. It was a very hammer and tongs move. Similarly, it was never asked. So some high courts reported that these judges are behaving in an ill manner to impose a 3-year practice clause. Now, the 3-year practice clause, nobody can ever argue against practice. However, it is more of a 3-year wait time before you even become eligible. So by the time they're 26, 27 and the examinations are not happening, they only take place once every 3 to 4 years on a very limited number of seats, and that too, they're very arduous examinations. They're extremely tough, and you need to have read a lot, prepared a lot in the most voracious manner. All of the people had left prep. And where will you find the best candidate pool? So big shout out to all the NLUs and the student bodies that wrote in that this will completely wreck the scene inside out, and that's why a review was warranted. And the biggest shout out, of course, goes to CJI Suryakant for understanding the situation. I know that he's been criticized a lot these days, and I, in fact, recently wrote an article as well that perhaps his criticism would have been a little less by this entire system had he just sounded better and his accent were better, but nothing going against the substance. But we are all open to criticism. Well, Justice Chandrachud was criticized. I get criticized a lot. No one is immune from criticism, and so is he not for if his statements, if they were not spun out of context, etc. But again, let me not go into the politics of the situation. So big shout out goes to him as well for understanding the situation, and thank God that he had attempted these examinations and was an aspirant way back then. Of course, life turned out to be brilliantly spectacular for him for other reasons. And so now this judgment understands and goes to the core crux of the issue. So now you have 1 + 1 + 1, that is 1 year of practice, and that was a certainty. Why? Because last year when this judgment was delivered on the 20th of May 25, 1 year had already elapsed. So thanks to the Sabrimala review of the 9-judge bench, the hearings got postponed from March till about July and August. The summer vacations came in between. So the correct thing, so 1 year had elapsed, so nobody would have had problem with a 1 year practice. I mean, nobody can argue against whether you are a candidate with physical disability, or you are a female candidate, or you are a candidate with with n number of factors. You cannot argue that practice is required. And I truly do hope, and I'm saying this as someone who provides coaching services for judicial services exams, and I run a full-fledged batch, that people do end up spending some time in the courtroom in addition to being exclusively available in a coaching classroom. So 1 year practice is a mandate. However, it has been given a one-time exemption till I believe March of 27, and I'm sure you know of all of these details. And then after that, we go to the 1+1+1 model, and then you need to go for 1 year of training under the State Judicial Academy, and then you need to do a clerkship of 6 months under a district judge, and a 6-month clerkship, I believe, under the High Court judge. And however, so you're not seeing the face of a courtroom being allotted to you 3 years post selection. So automatically your age is going to go up till 28, 29, and you would have seen the world by then, and then you are a far more mature person. And the bar just wants a lot of, not the bar, because that will be an extreme statement to make. But let me reframe it. Some members of the bar want an absolute closure of these posts to absolute first gens, so that they can get hold of these posts, because, well, arranging practice documents are they're very easy. So only their children with a lot of privilege could have attempted these examinations going forward. So now that concern is also, because you can arrange for those documents. We all know the realist, and let us subscribe to the American realist's point of view as to law is not what the statute says. Law is what the judge does. So law is actually what happens in reality. So this could have given them an unfair advantage, and that is why some members were absolute vehement advocates of the 3-year practice clause. And now the coaching guys were being blamed that you have a pecuniary interest and therefore you do not want this. So everyone has an interest. It is not that anyone is a doodh ka dula here, by the way. Now that has been addressed. Now a magistrate is going to have 1 year of training, 1 year of practice. They would have cleared a very tough examination, a pre-mains and interview. Then they have a 1 year of training. Then they have 6 months of clerkship under the district judge and 6 months of clerkship under the Supreme Court judge, a High Court judge. And if they still receive criticism कि इनको तो कुछ आता ही नहीं है, well, very frankly, I mean, like, really? Are you kidding me? How much of law does a fresh lawyer know out of law school any which way? And how much of law do they know even after 2 years of practice or even 3 years of practice? That document could have been arranged any which way. So, I mean, this shuts off most of the criticism by the bar, because now these people will be coming through the bar only, right? So that criticism has been shut out, at least for now, at least for 5 years, till the time that this issue rises up again, 2031, 32. God only knows who is who by then and who is where by then in life. So that is a good thing. However, the Achilles heel of this government, this judgment, and the most weakest point is that, let us say that there is a lawyer now out there with 3 years of substantial practice already under his belt, and again he'll be made to undergo 1 more year of training, then 2 clerkships under 6 months and 6 months. That could have been looked at, that the model, the model of the number of years of practice that you have, then perhaps we can get your training and clerkships in proportion to that. But you can't, one judgment can't satiate everyone. Everyone will be criticized, and the criticism is going to be there, and, well, that's the weak point of this judgment. This point could have been looked into. And another point could have been looked into was clarify whether a LLM is counted as practice. Because you have the license and you're pursuing an LLM, again, we are very silent on that issue. Then clarify whether law officers in PSU, they should, if they are working, even if they're working on legal matters only, so why aren't we considering them? Because as it is, the best talent already goes either into corporate and litigation, and never really truly comes back to these examinations to begin with, or they are forever perpetually focused on the UPSC. So therefore, when people have a myriad of options to consider, your examination, which doesn't take place on an annual basis, takes place once in 4 years on a very limited number of seats, then it's a 3-stage examination, then a very tough one at that. I mean, look at what Delhi Judiciary asks you in the Civil Law 2 ka paper. The wall had become too high to scale, and this examination had become completely unattractive for any person out there. Not merely to women, and I'm not undermining their criticism as well. So it's a great thing, at least we moved in the right direction, and thank you to all the stakeholders who fought this out, and this is the right thing to do. I know this will again attract a lot of criticism of a lot of members of the bar that we need better judges, etc., etc. However, what sort of a job are you offering them, first and foremost? What sort of a job, as in, again, I'm not demeaning this job. It's at the end of the day, your judicial magistrates are the first class with a good career progression available to you. And it's one of the most powerful jobs of the country. However, you should not pursue these posts only merely for these statutory benefits that you're going to get. You should pursue it because, well, you are a good judicial officer, and we need good, better, practical judicial officers out there. And practice does make you a good judicial services officer. However, considering the nature of the exam, this, I believe, is the best middle path, the most pragmatic, instead of trying for a very utopian solution out of the ivory towers at Tilak Marg. This is absolutely the best way possible, and that's why I'd written that this is going to happen, because there was no other way. It was just a mere logical deduction, and I have no insider sources, by the way. This was just a logical deduction, and I believe the judgment is absolutely correct. But this also has an effect because the pendency of the courts is so high. So after selection, now you're going to make them wait for 2 odd years, because 1 year to practice mein chala jayega pehli. After the 31st of March, now 27, let us be clear, you need 1 year of practice. Once you get selected in your chosen exam, then 1 year of training, and then 6 months. So you have a 2-year wait time before you get allotted a courtroom. I do not know what that does to the pendency, but it doesn't sound very good and doesn't look very good, especially if we logically have to draw out a conclusion based on this. And 1 year of practice, nobody is arguing. I was a proponent and advocate of even 1.5 years of advocacy practice. However, 1 year is absolutely fine, and 1 year of training also is fine, because you will already be preparing for the exam, so you'll be studying a lot. Preparing for these examinations and practicing simultaneously is downright impossible. Those who have done it know. And again, it's a very utopian idea to pass on to you कि हाँ सुबह practice कर लो शाम को ऐसे तो नहीं होती पढ़ाई. You need to give it, बलिदान है पूरा. It is no less than UPSC prep, even though it may be considered as that by a few. But we know, people on the ground know what it is, what sort of a behemoth monster it is to prepare for a judicial services exam. And I believe that this is a step in the right direction, no matter what is shortcoming, and shortcomings will be reviewed 5 years down the line. I do not agree at all with Justice Chandran's dissent, and because he was like, this is coaching sponsored, coaching guys have been hit hard, so therefore they are sending this petition under a proxy litigant, which is not the case, sir. If you're listening to this, which is absolutely not the case. And the NLUs, the non-NLUs, all the colleges who advocated for the clause to get dropped and advocated for a post-selection training were absolutely bang on correct in their assessments. And I wish every one of you all the very best for fighting it out there. And now it is time, if you truly just are aspiring for these jobs, to prepare, because, well, a lot of states are going to say dhappa to you. Might just say year end, might just say, might not say, might say. It is all speculation. And after the 31st of March, so till the 31st of March of 27, you do not even need that 1 year practice. However, most of you since last year would have completed the 1 year practice any which way, right? So I don't think that it will be too much of a problem. Of course, now the disadvantage is to those who had completed the 3 years of practice, and the lowest amount of competition would have existed had any exams taken place. Odisha, the state of Odisha did a critical error by barring, if you know of the controversy that they set the cutoff date. Even 1 year prior to that exam vacancy, there was some issue there. Maharashtra, I think, when they issued the notification, they wanted practice experience from within the state. If that is correct, I can't recall, because that notification was in their local language. And so all of these things, now let us see what the respective high courts will do, but they have been given a 3-month timeline to modify and amend their rules accordingly. Haryana PCS could have waited. They just notified the mandatory 3-year practice like last week only. I mean, like, are you not privy, or are you not aware of that the Supreme Court is just about to deliver the judgment? So it's a very slow, archaic system that you have to constantly fight at each and every step, and which people who have not experienced will, if I were not in the judicial services coaching program scene, I would have fiercely and vehemently, incessantly advocated for a 3-year practice clause, that this should not be removed. But once I was in the scene since 2024, I realized that the problems are a lot many more than they can ever possibly be explained to someone who has not been there, done that. So yeah, without repeating myself too much, I think it's time to wrap up this session, and hope to see you as a judicial officer, a good one at that. And please do not negate your practice. You must see the courtroom, you must be aware of the lawyer tactics, and you must always be connected to the ground. You need to have substance, and this is a very viable path for every student of law. However, do consider that whether you are cut out for this path or you're cut out for this life, do go out there in the courtrooms, be experienced in the interviews, in the clerkship. It will really help you a lot. And do prepare. It takes about 1.5 years to prepare, and do prepare relentlessly if you truly wish to clear this examination. Of course, it's not a guarantee, but it always helps. बिना पुरुषार्थ और पराक्रम के भाग्य फलित नहीं होता, हमेशा ये बात आप याद रखिएगा. And I wish you folks all the very best. Do take very good care of yourself, and may God bless you always. Do explore the playlists on this channel. Let me do a pseudo marketing of Itni Baat Hui on this channel. If you want to revise any subject, do go to Law School by TLOI. That will help you revise your entire law school in a sense. Just check out that playlist. You'll get to know, and you can check out jurisprudence, etc., all of the playlists. I wish you all the very best, and I thank again to all the stakeholders. I thank again all the stakeholders that were involved, and yeah, that's about it. May God bless you. You take very good care of yourself. See you when I see you. Bye.